of you have attended all 3 evenings of the Human Rights Forum, and we appreciate your interest. But whether you have attended one session or all 3, we thank you for coming. The Virginia Foundation for the Humanities and Public Policy deserves our deep appreciation, for without its assistance, the Human Rights Forum would not have been possible. At this time, our moderator, Dr. James A. Houston, Dean of the College, Lynchburg College, will introduce the program. Dean Houston.
We are happy indeed to welcome 2 distinguished speakers to Lynchburg College and the Lynchburg community and to this platform for the final session in our Human Rights Forum. Before we proceed, let me introduce briefly each of the speakers and the members of the panel. Marvella Bayh is a leader in the movement for women's rights and is also noted for her leadership in the programs for improvement of health care. She began her undergraduate studies at Oklahoma State University. There she was prominent in the speaking and debating. In fact, went to a national contest. It so happened at the same time there was a student from Purdue University by the name of Birch Bayh participating in that contest. She won. From that point, I believe he decided that if you cannot beat her, join her. And so they were married, and now, with her assistance, he became United States Senator. She went on to finish her B.S. degree in education at Indiana University. She was named in 1964 as the Indiana Woman of the Year by the Indianapolis Professional Society of Women in Journalism. She has campaigned extensively during the senatorial campaigns since that time. During her time in Washington for nearly 2 years, she was a television reporter for the Bicentennial on the Sunday Show. She's had articles published in Ladies' Home Journal, McCall's, World Health, Daycare Bulletin, and so on. And she and Senator Bayh have a son, Birch Bayh III. Mrs. Bayh, will you be recognized? Phyllis Schlafly. She's the founder and the national chairman of the STOP ERA. She's a member of the Illinois Commission on the Status of Women. And she's also an authority on national defense and foreign policy. When first proposed by the Congress, the Equal Rights Amendment seemed to be on its way to very early adoption. Some give her the credit or the blame for almost single-handedly having turned that around and prolonged the effort, which now continues. Mrs. Schlafly holds the B.A. degree with honors from the Washington University of St. Louis and an M.A. in political science from Harvard. She's a member of Phi Beta Kappa, Pi Sigma Alpha, and she's continuing her studies, and she hopes to be an August graduate from the law school of Washington University. She has had a number of honors come her way, including nine honor medals from the Freedoms Foundation of Valley Forge, Woman of Achievement in Public Affairs by the St. Louis Globe Democrat, and the Brotherhood Award to the National Conference of Christians and Jews. And she was listed in the World Almanac as being one of the 25 most influential women in the United States. She is the author of a monthly newsletter. She writes a syndicated news column. She's co-author of 5 books on national defense and foreign policy, and her other books include these, A Choice Not an Echo, Safe Not Sorry, Minzenti the Man, and The Power of the Positive Woman. She's the wife of attorney Fred Schlafly, and they have 6 children. Mrs. Schlafly, please be recognized. Now, as members of our panel who will be participating later in the discussion, we have 4 members of the Lynchburg College faculty, and on this side on the left and your right, Professor Jacqueline Asbury of the Physical Education and Health Department, who is Director of Intercollegiate Athletics for Women. Then Dr. William Young, Chairman of the English Department and of the American Studies Committee. He will act as chairman of the panel during the discussion period. Professor James J.H. Price of the Department of Religious Studies, and Professor Thomas W. Seaman, who is chairman of the Department of Sociology. Now, tonight's program is being carried by public television, station WVPT, and this may be seen, I understand, this coming Tuesday evening, February 28th at 10 p.m. on Lynchburg Cablevision, Channel 10, and probably will be shown elsewhere at a later time. Now, the rules of engagement this evening, according to the traditional rules of debate, as nearly as they can apply here, the traditional at least since 1903 at Lynchburg College, and according to this format, the affirmative speaks first and then has the final summary. For the initial speech, each speaker will be allowed 20 minutes. There will be no interruptions until the 20 minutes have elapsed. Then Dr. Young, as the chairman of the panel over here, is keeping an eye on the stopwatch, and he will sound the bell when the 20 minutes have expired, and then there will be 2 minutes of grace in which to complete the sentence or the thought just at that time. Now, if a speaker does not use all the time, that may not be banked and used at a later period, nor may the other speaker lay claim to it. That's the maximum. You may have a shorter period if they choose. Then after each has had the opening speech, in turn they will have a 10-minute rebuttal. And again, we'll have 2 minutes of grace in order to complete a thought after Dr. Young has sounded the bell. At the conclusion of the rebuttals, then, we'll ask that you pass the questions which may have occurred to you and you've written to the aisles as has been explained to you, and then we'll take a 10-minute intermission and reassemble to carry on the discussion. And we'll conclude then with the 10-minute summary by each speaker, first for the negative and then for the affirmative. So now to the question, should the proposed 27th Amendment to the Constitution of the United States, the Equal Rights Amendment, be approved? And taking the affirmative, Mrs. Bayh.
Thank you very much. It's certainly a pleasure for me to have the opportunity to be with all of you here at Lynchburg College. It was a special, happy occasion for me today when I found out that this college is a sister college to Phillips University in Enid, Oklahoma, which is my hometown where I grew up. So I feel right at home because I spent a great deal of time around the Phillips campus. Since we are here to discuss the Equal Rights Amendment, I thought I would share with you a story that Representative Millicent Fenwick, who's a congresswoman from New Jersey, tells about when the ERA was up on for discussion at their state legislature. She was then a member of the state legislature, and she said that one man stood up and he said, "I don't like this amendment. I just don't like it at all. I've always felt that women were sweet and cuddly and smelling good." Whereupon Millicent Fenwick rose to her feet and said, "You know, that's exactly the way I've always felt about men, sweet and cuddly and smelling good, and I do hope for your sake you haven't been disappointed as often as I have." When I look at the current effort going on in this nation to secure the final 3 states for ratification of the Equal Rights Amendment, I'm reminded of the efforts made by our founding fathers and our founding mothers. And I really think we need to remind ourselves that the struggle for equal rights for women has been with us from the very earliest days of this nation. Abigail Adams was a farmer and a businesswoman, and she thought the revolution would provide a marvelous opportunity for liberalizing the common law restrictions on married women. In March of 1777, she wrote to her husband, who was then attending the Second Continental Congress in Philadelphia, And in this letter, she wrote words that have now become famous. I long to hear that you have declared an independency. And by the way, in the new code of laws, which I suppose it will be necessary for you to make, I desire that you would remember the ladies and be more generous and favorable with them than your ancestors. Do not put such unlimited power in the hands of husbands. Remember, all men would be tyrants if they could. If particular care and attention are not paid to the ladies, we are determined to foment a rebellion and will not hold ourselves bound to obey any laws in which we have no voice or representation. Well, her husband was bullheaded on the subject of women's equal rights, and he wrote back to her, "As for your extraordinary code of laws, I cannot but laugh." Unfortunately, Abigail Adams' prediction was not to come to pass. There was no great wave of equal rights movement following the war for independence. Actually, within a very few years, American women assumed a position inferior to the one that we had had before the war, and the subject of women's rights was almost forgotten. The Industrial Revolution began to seriously limit the power of women in home industries, and soon English and American writers and moralists began to depict the proper role for ladies as one of modesty, meekness, obedience to their husbands, and weakness both intellectually and physically. Ladies did not want economic or political rights, and the symbol of a man's success became the idleness of his wife. Unfortunately, this has persisted into modern times. However, most widows and spinsters had to work, and you all know the very important role that American women played on the frontier of our nation. Very equal roles. Susan B. Anthony was probably the most famous of the suffragettes in our country, but there were thousands and thousands of others who did their part, who paid a great price to help further the cause of women's equal rights. And we today are their beneficiaries. I think it's important that we recall these events of years ago, for they were thinking and planning for us, you and me, males as well as females, because a free man needs a free woman. They wrote that their work was not for themselves alone, nor for their present generation, but for all women of all time. And I feel that they would be proud to see so many American men and women today organizing in support of the belief that all people are created equal. Indeed, they would be in the forefront, pushing for the passage of the Equal Rights Amendment. And we, you and I, are so fortunate because we, in our time, have the opportunity to complete the work which they began so many years ago. We women don't want to be men. We do want the power of our own individuality. We want options, the freedom of choice. And no one is truly free so long as they are dependent upon someone else for their own personal fulfillment or for their financial security. We are women, and we are proud of it. We know that we can think and act and accomplish and contribute, and that beauty and brains can go together. The world needs the best minds God can produce. There's so much to be done to find a cure for cancer. Oh, so many other important things. We need the best minds God produces. And we cannot afford to relegate to some inferior position anyone who has ideas and talents to offer and contributions to make. I sometimes wonder if Thomas Edison had been born a woman, if we'd all still be reading by candlelight. Frustrated women are a major lost national resource. Well, just how far have we come in providing true equality in this land of equality for one half of our citizens? Let's take a little look. The gap between what the average working man and the average working woman earns has grown larger in the last 20 years. For example, in 1958, a woman earned, on the average, at least 63% of the average man's earnings. Today, that figure is only 59%, and that is despite the Federal Equal Pay Act and despite the start of the Equal Employment Opportunities Commission in the early 1960s. Women today constitute over 36% of year-round full-time workers, but only 10% of those who make over $15,000 or more. 45% of all married women are in the labor force. The average woman college graduate earns about the same as a man who is a high school dropout. Yes, that's the fact. And who are the women who are employed outside of the home? Let's look at them. 15.5 million of them are mothers, helping to support their children, and oftentimes they are the sole support of the children. Nearly 8 million women are heads of families, either single, widowed, or divorced. Among families with incomes below the poverty line, nearly 40% of them are headed by women. When you discriminate against a working woman, you are discriminating against the children that are depending upon her for support. Over 52% of all American families today are two breadwinner families. Only about 40% of the jobs in this nation today pay a man enough that he can support his family on his income alone. Yet our laws and customs have not acknowledged this fact. The American stereotype of the family with a husband breadwinner, the wife home all the time, and 2 children represents only 7% of our population today. Then there are those who are forced immigrants out of a lifestyle that was destroyed by death or divorce. Many times with empty pocketbooks, they face triple discrimination because of age, sex, and inexperience. Over 70% of all divorcees are in the labor force, as are 22% of widows. Some people ask me, well, why do we need the Equal Rights Amendment? I think we need only look at the way in which our current legal system protects our nation's widows and divorced homemakers and current homemakers to answer that question. Currently, half of all widowed or single women over the age of 65 live on less than $2,000 a year. Most of these women have not always been poor, but their circumstances have deteriorated with advancing age. Let's look at a typical case, and I'm sad to say this is a true story. She was 53 years old when her husband died. She'd been a housewife for 31 years. Her children were grown. She's not eligible for Social Security until she's 60. That's 7 long years from now. She was told to do volunteer work, but she has to eat. She wanted to work for pay, but she couldn't find a job. She says, I have spent the last 30 years of my life doing work I thought was productive and important. Sometimes I liked it, sometimes I hated it, but I always assumed it was something worthwhile, something that needed to be done. And now I'm told that my experience in the home is only good for volunteer work, that I'm expected to go on working without pay. Well, if housewives were given some sort of credit for a salary, she'd have been eligible for unemployment insurance as well as medical benefits. But unfortunately, to be eligible for general assistance, her children would have to sign forms saying that they could not support her. And her housing payments couldn't be more than $96 a month, which meant that she would lose her family home and have to try to get into some sort of public housing. This is what it can be like to be a dependent widow and a woman in the United States of America today. Well, and since divorce has become so much more common, let's look at a divorcee's situation. As for alimony and child support, a startling small number receive either. According to a recent survey, only 14% of divorced women are awarded alimony, and less than 1 in 2 is granted financial support for the children, but the children don't disappear. Moreover, less than half of the payments arrive regularly, with compliance dwindling to almost zero as the years pass and the children's bills mount. When she decides to return to work, if she's been a full-time homemaker, chances are she enters the job market with no marketable skills and no employment background. She certainly has no seniority. Betty Berry is a consultant on divorce at the United Presbyterian Church, and she says, "A woman is not economically equal to a man, and this is the basic fallacy. Nor does she have a spouse at home to take care of the children while she works. Women lose valuable fringe benefits when a woman's workplace has been her home. Divorce wipes out her job, her health insurance, her pensions, and often her old age benefits. Facing old age without Social Security and Medicare is a frightening prospect, but it is a reality for a housewife whose marriage lasted less than 10 years. She is ineligible for the wife's share of her husband's benefits, and even after 10 years of marriage, she can claim it only when he retires. Of particular concern is the woman whose husband works for the federal government. If a divorce occurs, no matter how long they've been married, 30, 40, 50 years, she receives no retirement benefits. Some call the older divorcees the most discriminated against women in our society. A woman who freely chooses the career of homemaker should not be in a position where she is risking financial disaster. Significant problems are finally being recognized and discussed. The legal rights of the wife, the economic contributions of a homemaker, and sex and equality in the marketplace. But more needs to be done. It's a fact that women often pay higher rates for insurance than men for disability coverage and health insurance. There's repeated discrimination in applying for consumer credit despite recent federal legislation prohibiting the practice. Many times single women have to have a cosigner where a single man does not. Then there's that very important concern of overwork of women with jobs outside of the home. This is now being recognized as a worldwide problem. A more equitable sharing of the duties of housework and the care of little children between the mothers and fathers is essential to solving the problem of the overworked wife. Such sharing is a prerequisite to sexual equality. My grandmother, who was a pioneer woman and staked out a claim and worked shoulder to shoulder in the fields with her husband, used to say, "A man's work is from sun to sun, but a woman's work is never done." And how will all of this be changed by the Equal Rights Amendment? Well, first of all, it's important to understand that ERA would not take away a homemaker's right to choose the traditional role of wife and mother. Indeed, one of the major arguments in favor of the amendment is that it allows women to make that choice, rather than having the laws of the land restrict her options in choosing a lifestyle. Hubert Humphrey used to say, "The poorest people in this world are not those who lack money, but those who lack options." Mrs. Christine Durham is a Salt Lake attorney, a pro-ERA Mormon. She's the mother of 4 and an active church worker. Her husband is the great-great-grandson of the Mormon founder Brigham Young. She thinks the Equal Rights Amendment will help arrest the movement of many young people away from marriage and children. She says, "It can only contribute to the strength of the family if a woman doesn't feel trapped." The old English common law, which looked upon a married woman as property of her husband, is still reflected in too many of our laws today. Many state laws depict married women as inferior, fiscally irresponsible, and weak and childish creatures. For example, let me share with you just a few. In Alabama, women may not purchase land without their husband's permission. In all but 8 states, if they purchase a home in both of their names, and this is true in Virginia, if she dies first, he pays no inheritance tax. If he dies first, she must pay inheritance. This ignores the economic value of the work women do in their home, which, though unpaid, assists in the acquisition of the family property. The 1974 Georgia Code stresses the underlying inferiority of married women by stating, "The husband is the head of the family and the wife is subject to him. Her legal existence is merged into the husband." In Kentucky, a married woman may not sell or give her separately owned property without her husband's consent. In Indiana, North Carolina, Alabama, and Florida, a wife cannot sell her own property without her husband's consent. In Georgia, she cannot use her property as collateral for a loan unless he gives his permission. In Nevada and Louisiana, a husband can liquidate all joint holdings without even telling his wife about it. And even further, in Louisiana, a husband has the right to control the money that a wife earns outside of the home. In Virginia, women who dedicate their lives to running their homes often find themselves treated unfairly compared to their wage-earning spouses. For example, on the question of debt liability, while a husband's property cannot be taken to pay his wife's debts, hers may be taken to pay his debts, because of the presumption that whatever she has, she received because of something he did. This remains the law in the state of Virginia, despite the state of Virginia's Equal Rights Amendment. One persistent tradition in American society is that homemakers have received inadequate compensation and recognition for their contribution to society. This is reflected throughout our system in various ways, ranging from Social Security laws to not even being counted in the calculation of the gross national product. ERA is an attempt to recognize women as individuals with important contributions to make, whether we voluntarily choose to make these contributions in our home or by working outside of the home. Opportunity, freedom, the freedom to choose, equality. That's what the Equal Rights Amendment is really all about. Now as for myself. For 25 years, I've had a cherished marriage to a wonderful man. For 22 of those years, I lived completely and totally through him. 6 years ago, I was visiting with Abigail McCarthy when she was writing a book, and suddenly it all came pouring out. She's a good friend of mine, and I said, "Abby, do you realize that if I lost Birch, I would not only lose my husband, my lover, my best friend, the father of my child, but I would also lose my career, and that is too big a burden for either him or me to carry." Then I had a really serious illness from which I did not know if I would recover, and at a time like that, you really take stock of where you've been in life and where you're going. And I thought, well, if at the age of 38 it's over, it had been a wonderful experience, but I had one big gaping regret. And that was that I'd never done my own thing. I'd never stood on my own 2 feet. I'd always been involved, but I'd never had the thrill of knowing that I could support myself if push came to shove. And I was determined to correct that situation if I were only given another chance. I determined to correct it. I'd always dreamed of a career of my own, and now I have one. Perhaps your dreams are different. Perhaps your choice would be different. Freedom is having that opportunity to choose. And this is what the Equal Rights Amendment gives us. And this is what true democracy is in this country of ours. Let's finish building it this year.
Thank you, Mrs. Bayh. And now for the negative, Mrs. Schlafly.
Good evening, ladies and gentlemen. The Equal Rights Amendment says, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Suppose for a moment that we change one word in that amendment and substitute the word age for sex. Suppose we made it a constitutional mandate that you could not discriminate on account of age. Would you be for that? Now wait a minute before you answer. If we could not make differences of treatment based on age, we would have to abolish the Social Security system. My, that's highly discriminatory. People over age 62 get cash benefits that people under age 62 cannot get. If we could not discriminate on account of age, you would have to be able to vote down into the cradle. You couldn't have a cutoff age of 18. You get your American citizenship the day you're born. Suppose we substitute a different word for sex. Suppose we substitute the words income level. Do you think it would be fair or just to make everybody pay the same income tax regardless of your income level? Most people don't. The income tax is highly discriminatory. You not only pay a different tax, you pay a different rate of tax. And if we could not change rights and give different rights to different people based on income level, we would have to abolish welfare and housing loans and government scholarships and all these other evidences of our system in which we treat people differently when in fact they are different. Equality is a beautiful word, and in a lot of areas we do treat people equally. We all have freedom of speech, press, religion, trial by jury, due process. But in other areas, we treat people very differently. And we do think it is right and just to treat them differently when in fact they are different in order to promote the greater goal of social justice. Nothing could be more unjust than to treat people the same when in fact they are different. Under our system, the United States Constitution is the supreme law of the land. And of course, if we put ERA in the Constitution, every federal and state law and regulation, anything that is touched by public funding, would have to conform to the constitutional mandate. As a practical matter, what it would require us to do is to put all of our laws and regulations into a computer, which would then kick out what are called the sexist words: male, female, husband, wife, man, woman, boy, girl, and replace them with the sex-neutral words, which are person and taxpayer and spouse. Now, when you realize as a technical matter this is what the Equal Rights Amendment will do to our laws and regulations, then it is easy to see that in some areas it will have no effect whatsoever, and in other areas it will have a tremendous effect. Let's look first of all at the federal level. Take the matter of employment. The Equal Rights Amendment will have absolutely no effect on our employment laws because they are already sex neutral. They do not talk about man and woman. Our employment laws, especially the Equal Employment Opportunity Act of 1972, prohibits discrimination based on sex in hiring, in pay, in promotion, and it sets up the enforcement machinery, a very aggressive federal bureau known as the Equal Employment Opportunity Commission. There is absolutely nothing that the Equal Rights Amendment can add to what is already the federal law in the matter of employment. I just simply cannot imagine what any woman could want as a matter of law than what is already on the books and very aggressively enforced by the federal government, and of course that law applies in all the states. Take the matter of taxation. Our tax laws don't talk about male and female. Our tax laws talk about taxpayer and spouse. And so the Equal Rights Amendment will have no effect in the area of taxation. In the matter of credit, we have the Equal Credit Opportunity Act of 1974, a very extensive law that gives women everything they've been asking for in the field of credit. Now, there are other areas where ERA would have an effect. Take the matter of the military, which is a matter of federal law and federal regulation. Everything to do with the military is a matter of federal law and regulation. Many of you can remember that we had a military draft for 33 years of this century. The draft law always read, male citizens of age 18 must register. Now, that is a typical example of a sexist law. It imposes an obligation on one sex that is simply not imposed on the other sex. And there never was any demand to treat people, the two sexes, equally under the draft law. We had the draft law in all the wars of this century, and it always read male citizens of age 18 must register. If we have the Equal Rights Amendment, the next time we have a draft and a war, it must conform to the Constitution, and it will have to say all persons of age 18 must register, the sex-neutral word. And that will mean that our young women will have to report and be inducted just like our young men. But that would be only the beginning. We, of course, today have federal laws which exempt women from military combat duty. We have many women who've made the military their career, and they have the best of both worlds. They have the same pay, the same rank, the same fringe benefits, but they have the marvelous preferential treatment that they are exempted by federal law from combat duty. The Equal Rights Amendment, as the supreme law of the land, would, of course, change that. Now, don't let anybody tell you that this will just let women volunteer to go into combat. Combat is an involuntary situation. And we know, of course, that this would be the effect because the majority report of the House Judiciary Committee that reported out the Equal Rights Amendment said, and I quote, "Not only would women, including mothers, be subject to the draft, but the military would be compelled to place them in combat alongside of men." Of course, you could have exemptions if you had one eye or one leg, or exemptions for overage, because we don't treat people the same on account of age. But we could no longer have the exemption based on sex. The Equal Rights Amendment would deny that. Now, I really think you have to be kidding to say this is a great achievement for women's rights, that, oh, wonderful, the next war we have, our young women will be drafted and put in combat, just like our young men. And the plain record of history is that war is a much more normal condition of occurrence than peace. We seem to have one of these wars about every 10 years, unfortunately. Take the matter of education, another area in which we have federal legislation. The main law is called the Education Amendments of 1972, popularly known as Title IX. The key sentence in that law is very simple. It just says you can't discriminate based on sex in schools and colleges, the kindergarten to graduate school that get any federal money. Well, that sounds very simple. Everybody'd be for it. But when Congress was debating it on the floor, they suddenly realized that there are quite a number of schools and colleges in this country that are all girls or all boys schools or colleges. And they do discriminate based on sex. And did they want to wipe out the right of those schools and colleges to take only girls or only boys? And they decided, no, we don't. There are about 100 all-women's colleges in this country, Smith and Wellesley and Bryn Mawr, a few others that you know. There are a handful of all-men's colleges. So far as I can find out, nobody has ever counted up the number of elementary and secondary schools that are all girls or all boys. So Congress put an exemption in the law to allow these schools to continue to remain single-sex if they chose, and not to have to conform to the co-ed mandate that says you cannot discriminate based on sex. And so Congress passed that law, and you know what happens to a law when it comes out of Congress? It then goes into the appropriate bureau for implementation. HEW spent 2 years drafting the regulation for Title IX, and they came out with their preliminary regulation that said, well, among other things, of course we will have to make fraternities and sororities go co-ed, because fraternities discriminate against girls and sororities discriminate against boys. And the people who belong to those organizations called up their congressman and said, what in the world is going on? And Congress said, oh, we didn't mean that kind of nonsense when we passed that law. But HEW Secretary Caspar Weinberger said, that's what the law says. I have to obey the law. And so Congress passed a special amendment in a matter of a few months that specifically exempted fraternities, sororities, Girl Scouts, Boy Scouts, YMCA, YWCA, and Campfire Girls. And then HEW spent another year drafting its final regulation. And of course they were under pressure from the women's liberation movement to make the requirement that all classes and all sports be co-ed, because it is dogma with the women's liberation movement that there really isn't any difference between the sexes, and the only reason that girls can't play football equally with boys is because girls' sports have been denied an equal amount of funding. But HEW had one problem. Their regulation would not become law unless it were signed by the President of the United States. And they knew there was no way they were going to get former All-American football player Gerald Ford to sign a regulation that made football co-ed. And so when they came out with their final regulation, they exempted football, basketball, boxing, wrestling, ice hockey, and rugby, but slapped the co-ed mandate on everything else. Well, the regulation went into effect, and then after that, the HEW extremists went running around the country trying to stamp out vestiges of sex discrimination, and the next thing they found was the American Legion program called Girl State and Boy State, a good citizenship program that sends high school girls to one school for a weekend of good citizenship training and boys to another. And HEW said that's sex discriminatory. You will have to combine them and make them co-ed. How did HEW get into the business of telling the Legion how to run its program, that its finances? Well, it seems the Legion was permitted to put its posters on the school bulletin board, so HEW asserted jurisdiction. Again, the Legion had to call up their congressman, and again Congress had to pass a special amendment exempting Girls State and Boys State. The following year, HEW discovered the terrible menace of mother-daughter, father-son events. It seems some schools were having father-son baseball games, and some schools were having mother-daughter fashion shows, and this was a terrible example of sex discrimination that must be wiped out. And again, Congress had to pass another amendment making a specific exemption. Now, this experience teaches us a lot of lessons. It teaches us, first of all, that when you have a mandate that says no sex discrimination, we just discovered that there are a lot of exceptions that reasonable people want. Maybe you don't want to join those particular activities, but most people don't have the desire to wipe out the constitutional right of other people to do so if they choose. This lesson also teaches us that when you're dealing with a statute and you find a problem, you can remedy the problem in the matter of a few months with an amendment. But if you're dealing with the United States Constitution, there's no way to change it except by the agonizing process of another constitutional amendment. It teaches us also that if we slap the constitutional override of ERA on all of the existing laws in our country, it wipes out all the exceptions to the mandate against sex discrimination, because there are no exceptions in ERA. The proponents would not permit it to have any exceptions, no matter how reasonable, no matter how many reasonable people want to have such exceptions in the law. Looking at the state level, this is the area where we have traditionally handled the matter of marriage and divorce and child custody, family property law. There are certain variations from state to state, but your average state law does make it the obligation of the husband to support his wife. Those are good laws. Those laws are based on the obvious fact that women have babies and men don't have babies. And that's the world we live in, whether people want to get rid of stereotyping or not. But they are sexist laws, and the Equal Rights Amendment would not permit any law to remain on the books that says husband must support his wife, because that is a sexist law. And that is how ERA is the great wiping out of the right of the homemaker to be in her home and to be able to take care of her own children in her own home. There are today some 40 million wives being financially supported by their ever-loving husbands. I think what is so evil about the Equal Rights Amendment is that it comes along and says to those 40 million husbands, as a constitutional mandate, that's not your primary obligation anymore. Now I realize on the college campuses there are many young people who think the wave of the future is to have equality of financial obligation. That's one point of view. I don't agree with it, but I know that a lot of them think that. But what right do they have to come along to the women who went into marriage 10 years ago, 20 years ago, 30 years ago, 40 years ago, and say, too bad for you, sister. We're changing the terms of your marriage contract. This is the age of equality. That is the big ripoff of the Equal Rights Amendment. And then there's another aspect to this, and that is Section 2 of the Equal Rights Amendment, which says Congress will have the power to enforce it by appropriate legislation. This is what shifts from the states to the federal government the whole area of subject matter that is covered by Section 1. This is the federal grab for power. This is what gives the federal politicians and the bureaucrats and the federal judges a whole new area to cover that they've never had before. And very big in this area that would be transferred to the federal government is the matter of marriage and divorce. Under the Equal Rights Amendment, what Section 2 would mean would be maybe you would pass a marriage and divorce law that would be perfectly constitutional, but Congress can come along and say, we don't happen to like the way you did it. We are giving you a national divorce law. Now, I, for one, think that the United States federal government is having a very difficult time solving the problems that it already has. I don't see anything to be gained in terms of justice or improvement in our society to give the federal people this whole new area of jurisdiction. There are 7 other amendments to the Constitution which have that same language. Congress has the power to enforce by appropriate legislation the provisions of this article. There has been a great deal of Supreme Court interpretation of that language under those other amendments, and we know exactly what it means. We know that it is a tremendous moving of power from the states to the federal government. We know that it not only means that the federal government and the federal courts can invalidate state laws that don't meet that standard. It means that Congress can come along and simply supplant its judgment for the states. And that is the shift of power that would occur under the Equal Rights Amendment. I think this effect of the Equal Rights Amendment is the reason why the biggest push for the Equal Rights Amendment comes from the people who work for the federal government. The Equal Rights Amendment would be dead today if it were not for the artificial respiration breathed into it by the people who work for the federal government. This is where the big push comes from. It came out in 1972. It was ratified by many states without any hearing or debate. They just called it up and passed it. But in the last 3 years, only one state has ratified. That one state ratified by only one vote, and that was after tremendous federal pressure. The federal pressure comes particularly from the executive branch of the government. We have had a situation in the last few years where a full-time federal payroller working right out of the White House, using the White House telephones, has been calling up state legislators saying, Big Brother in the White House wants you to hurry up and vote yes on ERA. Working full-time, the strategy meetings for the ratification of ERA are held in the White House. They weren't content with that. They gave $5 million to Bella Abzug's Commission on International Women's Year. And what did they do at their very first meeting? They passed a resolution by a vote of 35-0, making ratification their highest priority and pledging, quote, to do all in our capacity to see that the Equal Rights Amendment is ratified at the earliest possible moment, close quote. If we had had $5 million, I can tell you we would have buried it several years ago. But that is what keeps it going. And the enormous horde of people working for the federal government who were sent down at the taxpayers' expense to that shocking celebration in Houston, where they had their 4 hot-button issues, ERA, lesbian privileges, massive universal federal child care, and abortion on demand funded by the government provided to teenagers without their parents' knowledge or consent. And that is what they're doing with our money, and ERA is the centerpiece in that whole design. But still, even with all that federal money, they still have not been able to convince the majority of people or the majority of states that they want it. And so they have called a boycott, an economic boycott on the unratified states, trying to bring economic losses, throw people out of jobs in the convention cities in the unratified states, particularly Chicago, Atlanta, Miami, New Orleans, Kansas City, and Las Vegas. They are bragging about the hotels they're hurting, the millions of dollars of financial losses. The waiters and the maids are throwing out of work innocent bystanders who have nothing whatever to do with the ERA fight. They may even be for ERA. But the ERA proponents are on this vindictive campaign to hurt innocent people in order to pressure and bully the legislatures into ratifying something that they do not want to ratify on its own merits. They're running out of time, and they see that they're not going to make it by March 22nd, 1979. So now, in an attempt to change the rules in the middle of the game, they are demanding a 7-year extension. I can only hope that they won't get it, because 7 years is long enough to debate this issue, and I believe the votes of the legislatures have clearly shown that the American people reject the fraudulent Equal Rights Amendment.
Thank you, Mrs. Schlafly.
The Equal Rights Amendment doesn't change the Social Security laws of this land except to make them apply to husbands as well as wives. The way it is today, a wife can pay into Social Security, but if she dies, her husband doesn't necessarily collect any of her benefits, as happens with women when their husbands die. Let me stress to you that equality does not mean sameness, and no one said that it did. But I do believe that God created little girl babies with just the same care and love as he created boy babies. She mentioned words that were used, sexist words that would be removed from our language. I don't find anything sexist about those ringing words, of the people, by the people, and for the people. It doesn't say male people or white people. It says that this country is of the people and for the people. ERA will affect the employment laws. She mentioned that the employment laws are already on the books. The fact is that they are not being enforced. They're not being enforced at all, as the statistics show. Women are making less now, as I mentioned, than we were 6-7 years ago compared with men. And as long as it's not part of the Constitution, a simple law can just be changed with another act of Congress taking it away. And as long as it is not a part of the Constitution, each individual case of discrimination must be taken to court. Now, how many nurses, how many school teachers, how many waitresses can afford the time and the money and the effort to spend weeks and months in court appealing their case for discrimination? Now, these equal laws that she says are already on the books only apply to pay, and as I say, they're not being enforced there. But they say nothing about inheritance or pensions or insurance equality. Well, then we came to the subject of the military. No one, or very few people, really ever want to serve in the military, especially in combat at the time of war. Let me remind you, at the very height of the Vietnam War, only 5% of those eligible to be drafted were drafted, and only 1% of those eligible men in this country ever went into combat. Now, the fact is that the Congress has the right now to draft women into the military. And of course, they would always put exemptions, but they would be equal. Like they could exempt mothers, and they would exempt fathers equally. An old soldier had this to say: "Like most old soldiers, I was violently against women soldiers. I thought a tremendous number of difficulties would occur. None of that occurred. In the disciplinary field, they were a model for the Army. More than this, their influence throughout the whole command was good. I am convinced that in another war, they have to be drafted just like men." And that's a quote from Dwight David Eisenhower. Now, nobody wants to be drafted, but women have an obligation just as men have an obligation. And many times young people find that the military is a way to lift themselves by their bootstraps out of poverty pockets in this country. And yet girls today do not have that same equal opportunity as boys. Because in order to go into the military, a girl must be a high school graduate, where a boy does not today. So there is...
And now for her rebuttal, Mrs. Schlafly.
Yes, and first of all, in regard to Section 2, the Supreme Court interpretation is exactly as I said, that it does give the power to the federal government to preempt the decisions made by the state legislatures, and I suggest that you ask your lawyers to tell you what the cases of Katzenbach versus Morgan and Jones versus Mayer mean. They mean exactly that. In the matter of Social Security, which was mentioned, the statement that husbands don't collect on their wives' Social Security as wives collect on their husbands is simply untrue. It was corrected by a Supreme Court decision of about a year ago. In regard to private schools and colleges not being going to have to go co-ed under ERA because they are not subject to government regulation, that simply is not true. Practically all colleges, including the famous private colleges which I named, Smith, Bryn Mawr, Wellesley, and so forth, as well as Harvard, Yale, and all the rest of them, are subject to Title IX because they are getting federal money. But they have the specific exemption that they do not have to change their admissions policy if they don't want to. And in addition to that, we have the rather recent case of Runyon versus McCrary, under which the Supreme Court required an absolutely private school which held no tax exemption and got no state money to admit blacks, although it did not want to do that. And the government said if you're a school, you cannot discriminate on the basis of race. Now, I am not arguing the race matter. I am only saying that what the ERA proponents want to do, and what all their legal activity indicates that ERA will do, is to treat sex exactly like race. And if you apply the Runyon versus McCrary rule to sex, that will mean that no school will have the right to be single sex. Now, I'm very glad my opponent admitted that women will have to serve in combat just like men, and that is the obligation. Yes, Congress has had the right to draft women in the past, and for 200 years and 9 wars, they have used that right to exempt women. They could have all kinds of other exemptions, but they could have no exemptions on the basis of sex under ERA. Yes, women do serve in the military very honorably now, but remember, they are all volunteers. And it is a matter of whether you want to impose combat duty involuntarily on women or not. We were told that we have a hodgepodge of state laws. Yes, that's our system of government. We do believe in having a lot of variations from state to state. The very uniqueness of our country is that it is an interlacing checks and balances between state powers and federal powers, executive branch powers, federal legislative powers. And that is the way our system is set up, and nothing is gained by the centralization policy which would come under Section 2 of the Equal Rights Amendment. We were treated to some slurs on the Founding Fathers and a statement of Abigail Adams saying that all men would be tyrants if they would. Well, I don't think that's so, but in any event, these so-called alleged tyrants, in drafting the United States Constitution, wrote the most beautiful sex-neutral document that's ever been written. If you will examine the U.S. Constitution, it doesn't talk about males and females, men and women. It uses such sex-neutral words all the way through as persons, citizens, inhabitants, speakers, officers, senators, electors, members. Every one of them a sex-neutral word. Male is mentioned in only one obsolete paragraph of one amendment, which is no longer in force. We were told that Abigail Adams cried around about the restrictions placed on the property rights of married women. That was all remedied in this country back in the Married Women's Property Acts that came in all of our states around 1840. And it was back in 1875 that the U.S. Supreme Court specifically held, for those who needed to be told, that women are persons and are citizens in our system and entitled to all constitutional rights and guarantees except the right to vote, and we got that in the Women's Suffrage Amendment, so you don't need to worry any longer about women not being persons or not being citizens. We were told about the plight of women not being able to inherit enough from their husband. Under the Tax Reform Act of 1976, one spouse, either one, can inherit from the other $370,000 tax-free. That sum will rise to $420,000 tax-free in the next 3 or 4 years. And since most of us are under that amount, we don't need to cry anymore about the terrible problems of inheritance as between husbands and wives. We were treated to a bleeding heart line about poor women who only have income of $2,000 a year. Well, now, we would like to raise everybody's income, but please don't be under any illusions that the Equal Rights Amendment is going to come along and give everybody an income rise, or even all widows an income rise, because it simply doesn't happen. People are unemployed. They do need jobs. You'll have to look to the private enterprise system to create more jobs. You cannot look to the Equal Rights Amendment to create jobs. It simply is not going to do that. We were told that there are certain restrictions on property rights of wives, even existing now. There are certain variations from state to state. And again, that is a matter of state law. If you don't like the way your state law is, you can change it. In our state, we have no laws that discriminate against women. The Status of Women Commission, which is wholly dominated by the women's livers, abolished their Legislative Action Committee this year because they said there's nothing more for them to do. We don't have any laws that discriminate against women. But in a lot of these states which have not ratified the Equal Rights Amendment, the wives have very superior property rights. In many of those states, a wife is immune from the debts of her husband. Husbands can't be immune from the debts of their wives. In many of those states, a husband cannot sell or mortgage his house without his wife's signature. That's a very, very, very valuable right. In many of those states, there are very special advantages that widows have. Sometimes they get double indemnity if they've been cheated. In one state, in Florida, widows have a particular property tax exemption. And would you believe the ERA proponents were so mean that they took that law all the way to the Supreme Court to get it knocked out because it gave preferential treatment to widows? Fortunately, the Supreme Court didn't go along with that line, and in the case of Kahn versus Shevin, they said, under our existing Constitution, if the Florida legislature wants to give widows a special little helping hand, they being a group of people who need a little special help, that is okay. Of course, under the Equal Rights Amendment, that would not be permitted because it would be wiped out. It is not sex equal, it is preferential treatment for the widow. We were told that women pay higher rates of insurance. If you balance it all out, women get the better of the insurance deal. They pay lower rates on life insurance. And believe me, I'm paying automobile accident insurance on both daughters and sons under age 25, and the disparity is just tremendous. Again, a preference to the women. I am glad that my opponent finally admitted that ERA isn't going to come in and allocate the responsibilities inside the home, because in her opening statement, I certainly got the impression that ERA was going to require men to do half the housework. If you are under any illusion that ERA will do that, believe me, it will not. On the matter of the contact sports, we don't know how the courts are going to decide. We had the case just a few weeks ago of that avant-garde federal judge up in Ohio who threw out the HEW regulation and said it's highly sex discriminatory to bar the girls from the football and the boxing and the wrestling. They have every right to be there with the boys, and he held the HEW regulation unconstitutional. Now, I think he'll be reversed on appeal, but I think there's no question but that this is the nonsense of ERA. If you put in a constitutional mandate that is an override over every difference of treatment, then you will have the judges holding these things, and the final decision will be in the hands of the federal judges. You will have no say-so. You won't be able to change it by state law or even by federal law, because the decision-making power will move to the federal judges. Now, we were told of certain actual factual differences in earnings between men and women. I am one of those women with 2 college degrees who doesn't make any more money than a male high school dropout. I am one of the many women who just works part-time, and that's the way my income is. And I think that shows you the fallacy of that kind of statistic. Also, when you compare the earnings of men and women, if you would compare the earnings of single women and single men, you would find no difference at all. And if you would compare the differences, no, the Labor Department statistics will show that if you compare single women to single men, they come out the same. And furthermore, you have to also feed into those statistics the differences in years on the job. There's no way women are going to be earning the same as men if they have not been an equivalent number of years in the workforce. Now, we were told that that the employment laws are not perfectly enforced. Of course they're not perfectly enforced. But we have laws against murder, and we still have murders. I do not think that if we put a constitutional amendment abolishing murder, that would get rid of murder. But we do hope for better enforcement. But I think for every one you can show of a woman being discriminated against in pay or employment, I can show you one who got her job on affirmative action, even though she was not as well qualified as the male applicant.
Our thanks for these remarks in both cases, and my congratulations on adhering to the time schedule so precisely. And now, if you have questions which have occurred to you and you have written, and we'll write them now, if you'll pass them to the aisle, we'll ask the ushers to bring those to the panel so that they can be looking those over, and then we'll take our little intermission. So please prepare the questions and pass them to the aisle.
As you can see from our table up here, we've been completely swamped in questions. I think each one of you has submitted at least one question. Obviously, we're not going to be able to get to every single question. We probably have not read many of them adequately, but we've tried to skim off what we feel are some of the more general questions, the ones that are repeated most, those that seem to reflect audience interest. Now, what we're going to do is I will read the questions and direct them to either Mrs. Bayh or Mrs. Schlafly, and she will have 2 minutes in which to answer, roughly, and then I will give her opponent 2 minutes also in which to rebut or to argue the answer further. So obviously we will not be able to get to every single question. I hope that your question will be at least alluded to. If not, our apologies, but there's simply too many and not enough time. So let's get right to the questions, if we may. And my first question is to Mrs. Schlafly, and it is this. Mrs. Schlafly, are you saying that under ERA, fathers would not have to support their children in the event of divorce?
No, I didn't say that at all. I said that you cannot impose a different or unequal obligation on one spouse from what you impose on the other. I'm saying that the obligation would have to be equal. Equal in marriage, in regard to the financial obligation during marriage, which I think is really the more important part of what I had to say. There would have to be an equality of financial obligation to support the children after marriage. It would have to be equal. That is the whole problem of the matter. And we have, as I said, 40 million wives who are in the home, who are being supported by their husbands. Now, I asked the leading legal light of the ERA proponents, Professor Emerson of Yale, what will ERA do to, say, the typical marriage law that says husband liable to support his wife? And he said, we will change that under ERA so that the obligation will be mutual or reciprocal, and each will have to support the other if he or she is incapacitated. And I said, Professor Emerson, I'm a homemaker and I'm not incapacitated. And he just said, that's right, you're not. Now, when is a wife incapacitated? Only the week after she has a baby? And all the rest of the years of her married life, she's lost her right to be supported. Now, the wife has obligations. If the husband's unemployed, incapacitated, ill, or whatever, she has obligations. But it isn't equal. And I feel that it is right and just for the primary obligation for financial support to be on the husband and father in recognition of the factual difference that women have babies and men don't have babies.
Mrs. Bayh, would you like to respond to that?
Under ERA, each individual case would be looked at for what it really is. and it would be taken into account the contribution and the value of that contribution that the woman has made in the home. If she has stayed home and forgone her career outside of the home to stay there and be a wife and mother, then that would definitely be given value, which it is not today. And this business of support really is almost voluntary today because, as I pointed out, no state will go into an existing marriage and interfere. They even hesitate to do it in the case of extreme wife beating. Why? And so of course they don't do it if they just don't feel support is being carried on. Now in divorce, only 14% of the women get alimony today and less than half collect it. And in child care and child support, less than half get child support, and it dwindles through the years. Maybe you read Ann Lander's column last week or the week before, which was really a heartbreaker. This young girl wrote in, probably about 14, and she said, "They say I'm pretty, except for my teeth. And my dentist says I need braces badly. My mother and daddy are divorced. Daddy's supposed to pay my medical expenses. Mother's working to put food on the table. She doesn't have any extra money for braces. Daddy says he can't afford it, but he was able to buy his second wife a new fur coat." And that's what happens too many times in this country today with the way it is today.
And this question, Mrs. Bayh, is directed to you. The question is, what will ERA do for elderly 60 to 65 years of age living on less than $2,000 a year?
You said less than 65 years of age?
No, for elderly 60 to 65, and I assume, or older, but living on less than $2,000 a year.
What it would do for women today coming up and middle-aged women today, it would help them to get jobs, be treated equally, be paid equally when they go to get their jobs. For example, today I think it's just terrible that a school teacher, a woman school teacher who retires, receives less in retirement than a male school teacher who has taught the exact same number of years at the exact same level and is paid in the exact same amount of money into retirement. These people need to be protected in retirement, and the reason women today over the age of 65 are in the miserable shape that they are in is that our inheritance laws discriminate against them, the pension laws discriminate against them. Now, I can tell you, my husband and I own a little vacation cabin in Virginia outside of Front Royal, and I asked our lawyer, I said, if something happened to Birch, what would be the situation on that cabin? He said, it's jointly held. And he said, you would have to pay inheritance on half of it. And I said, well, what if something happened to me first? And he said, he would not have to pay inheritance on his half. That's the way the law is. Now think about the farm women whose husbands die. Sure, there is exemption, but not all that much exemption. So ERA would correct hiring discrimination. It would correct pay discrimination. I don't really believe that it would do too much for women right now today that are over the age of 65 if they've already gone through the inheritance trauma and already had to pay, but would correct it from happening in the future to the next generation of women.
I just don't think my opponent's lawyer has read the Tax Reform Act of 1976. The whole law of taxation in regard to jointly held property and the shifting of property between spouses has been so fundamentally changed and made very generous that I really think most of us are under the $370,000 exemption that is tax-free as it goes from spouse to spouse at the present time. In regard to, I'm glad it's conceded that women over 65 are not going to be helped by ERA. I don't think any women are going to be helped by ERA. But don't be under any illusion that ERA is going to find jobs for people. A constitutional amendment does not create jobs. The American private enterprise system creates jobs when it puts approximately $30,000 of investment to create a job. The only other way you get jobs is if you hire people by the government and take the money out of somebody else's pocket. But we have a very high unemployment at the present time, higher than we've had in many years. Now, to send X number of millions of women out into the labor force to hunt for jobs just simply means more people are unemployed. The pay and the hiring in regard to sex discrimination is all completely covered as a matter of federal law today. And in the matter of pensions, if a woman has paid into the pension exactly the same as a man who has paid into it, obviously she is not going to draw out quite as much when she retires because she's going to get it for more years. It is a plain fact of life that women live longer than men. And you have to equalize it some way unless you are asking for preferential treatment.
Ms. Schlafly, I will direct this next one to you. It is, are you in favor of a full legislative vote on the ERA in Virginia?
Well, I am not in favor of my telling the Virginia legislature how to run its business. But we do have the committee system in parliamentary government, both at the state level and at the national level. I think, as a matter of fact, that the state of Virginia has done more to study ERA than any other state legislature in the Union. They set up a task force and made a complete and exhaustive study from, made by distinguished lawyers from every one of the law schools in the state of Virginia. And that Virginia Task Force report has been extremely helpful in guiding the legislators how to vote. And after you read that Virginia Task Force report, there's just no way that the majority of the members of that committee could possibly vote for ERA. So I think Virginia has given ERA a very adequate hearing. But I'm interested to know that my opponent doesn't approve of bearing constitutional amendments in a committee, and I will tell my friends in the pro-life movement that Senator Birch Bayh will soon be releasing the Human Life Amendment from the committee that he's kept it buried in Congress and won't let it out.
He has had hearings and has been in the process of having hearings. It's a very complicated problem, and it will be coming out. Now, I would like to just say, I would like just to say a word about the Virginia legislature. I do not feel that that can be democracy in action when 12 men keep it from coming to the floor. I have heard over and over again people say, I don't think I'll vote for it when it gets to the floor, but I'm going to vote for bringing it to the floor. And that's democracy in action. I would like to just comment that my opponent said that women deserve to get smaller pensions than men, even though they paid in the same amount, because they might happen to live longer. Well, I just want to point out that during those years that they're living longer, they do have to eat and have a roof over their head. And I would like to mention, as far as the widows in our country are concerned, especially those widows in Florida who were given preferential treatment, that under the Equal Rights Amendment, that would not be taken away from them, but that same preferential treatment would have to be given to widowers.
Mrs. Bayh, this next question is to you. Is it not true that ERA would provide that sex was suspect, whereas we presently must prove sexual discrimination? In other words, gender is suspect rather than discrimination.
I'm sorry, I don't understand the question.
Let me repeat it. Is it not true that under ERA we would have to provide that sex or gender itself was suspect? In other words, we would have to prove that one's gender is the question, whereas now we presently must prove sexual discrimination. In other words, man or woman would have to simply prove not discrimination, but simply that because they were a man or woman,
I'm not sure I really understand the question. But what it would do would just say that each individual would be treated as an individual. And you wouldn't be treated one way or the other because of your sex. Now, you know, in times past we've discriminated against people because of their color, because of their nationality, because of their religion, and this would simply write sex into those areas that you cannot discriminate against, that you must give equal opportunity to that individual to become all that she or he are capable of becoming. I often think about that story that woman was taken out of man, not out of his head to top him, nor out of his feet to be trampled underfoot, but out of his side to stand equal to him.
Under our present Constitution and the 14th Amendment, you are entitled, or a legislature is entitled, to make rational differences between different groups of people when in fact they are different if they have a good reason for doing it. Now, you know that in the past decade we have prohibited the doing of that on the basis of race. In legal jargon, this has been called making race a suspect classification. In other words, you can't make any difference no matter what kind of argument, even a so-called reasonable argument, that people might think up. Now, what the Equal Rights Amendment would do is to do for sex exactly what we have done for race, which is to take it out of the types of classifications that you can argue rational reasons and move it over to the type of category like race, where the court isn't going to hear any reasonable reasons. They're just going to say you cannot discriminate or make any difference or separation on that basis. Now, everything that the ERA proponents are doing and all their litigation shows that this is exactly what they want to do. And they say that ERA will make sex a suspect classification. And that means no matter what type of rational reason, no matter how many reasonable people might want it, you cannot make the difference. So your best prediction as to what the Equal Rights Amendment will do is to ask yourself the question, how do we handle it on race? And you know, of course, we cannot have black schools and white schools, therefore you would not be able to have male schools and female schools. You cannot have black football teams and white football teams. You cannot have any type of separation. You know that it is the law of our land that separate but equal is not equal. By definition, separate but equal is not equal. So it is the co-ed mandate straight down the line, and that is what the ERA proponents. And the same thing would apply to the draft in the military or whatever. No matter what kind of reasonable reason, you can't do it.
All right, Mrs. Schlafly, this question is to you. If the United States Constitution is sex neutral, why were women not given suffrage until 1920?
Very simple. Under our system of government, and you all should have learned when you went through high school civics, we are a government of delegated powers. And those powers which were not delegated to the federal government were reserved to the states and the people under the 10th Amendment to our Constitution. Among those rights and responsibilities which were clearly and emphatically reserved to the states and the people under the United States Constitution was the right to establish the voting requirements. That was not a federal power. That was a state power. And prior to the Women's Suffrage Amendment, the majority of our states had given women the right to vote. A lot of people are under the illusion that women didn't vote in this country prior to the Women's Suffrage Amendment. That is absolutely untrue. Women voted in most of the states of the Union prior to the Women's Suffrage Amendment. But when we voted in the Women's Suffrage Amendment, we did federalize that particular function. We said we are going to have women vote in every one of the states in this union, and then we moved that power to the federal government. Under our system of government, the federal government only has those powers which are given to it by the states. And in the matter of voting, the federal government has only gotten certain powers in regard to elections.
Mrs. Bayh, would you like to respond to that? If the United States Constitution's wording is sex neutral, why were women not given suffrage until 1920?
I believe that was a very, very good question, and I couldn't help but think when my opponent was speaking earlier, she was saying that there was really no need to make equality a federal law, to let the state, federal part of the Constitution, but let the state laws take care of it. I wondered if she would abolish then all of the constitutional amendments and all federal laws and just let the states run everything, including the right to vote. I think you can carry this ridiculously far. Our Constitution is a great document. It states what we really believe are the fundamental basics of life in a democracy in the United States of America. And we would hope that it would state what we believe in the 20th century as well as what we've believed in times past. It's a great document. It's a cherished document. And it's important to write into that document for a little over 50% of our people that you are not second-class citizens, that you will be treated as an individual, and you will not be discriminated against because of your sex. Now, I realize that this type of segregation or discrimination that I'm going to mention is no longer in practice, but I did face it myself. I was a girl growing up in Oklahoma, and I fell madly in love with Thomas Jefferson. When I was 14, my parents promised me a trip through Virginia and to the nation's capital. So I decided that it was a dream of mine to go to Mr. Jefferson's University at Charlottesville. Imagine my sadness when we went for the interview to find that although I was an honor student, almost straight A's, and had all the credentials, simply because I was female, they wouldn't even consider me. Now that, of course, has been corrected, but there are other glaring inequalities that have been mentioned here tonight earlier by me that are just as hurtful to the woman today trying to make her place in this world, whatever she chooses her place to be.
Mrs. Bayh, this question is for you. In a job requiring in part great physical strength, the average woman is not as likely to be able to do it because of the natural makeup of her body. How then can she expect equal pay?
Yes, under the Equal Rights Amendment, all laws would affect men and women the same. There are men that cannot unload refrigerators. I've seen a few women that can. And everything would be according to what the individual can do. Now, many of the laws that have been passed under the pretense of protecting women actually discriminate against women as far as advancement is concerned. It is said that they can't lift more than 30 pounds. Well, our son wasn't walking when he was over 30 pounds, and I lugged him around on my hip, and I lugged groceries into the house. So some of them are ridiculous. Others say that you can't work overtime. Well, what person in a management position can really get there without putting in some overtime? So what ERA would do would be wipe away that type of discrimination. It would be say, can you as a person physically handle this job as a man or a woman, the equal job? And those statistics I gave you earlier in the evening applied to men and women who were full-time employees doing similar work. The other laws that are really beneficial, like rest periods or health protection, would simply be extended to cover men as well as women under the Equal Rights Amendment.
Schlafly, would you like to respond?
The overtime laws never applied to management jobs. They apply only to factory-type jobs. In regard to lifting, the lifting that you do of your own babies, and I've done plenty of that, in no way can be compared to a factory job where you might have to lift a 50-pound load every 45 seconds on an 8-hour shift. That is quite a different story. This is a great myth that the protections that exist under ERA would be extended to the opposite sex. Let me remind you that the Equal Rights Amendment does not establish any level of benefit There's nothing in ERA that says that existing rights or benefits on one sex must be extended to the other. That is not what ERA says at all. All ERA says is that it must be equal, and you can be equal by going up and you can be equal by going down. And if one side has a tax exemption and you have to have it equal, you very well lose the tax exemption. There's nothing in the world that says both sexes get the tax exemption. And there's nothing in ERA that says that both sexes get a rest period. What our experience has been is that when you have the equal mandate, both sexes lose the rest period and lose the sofas in the restroom and the other additional preferential treatment that women in working persons' jobs have had. Now, in the enlisted persons' jobs in the military, the latest report of the Air Force Surgeon General shows that on the average, women have only 60% of the physical strength of men. Now, what does this mean? That means the women are assigned to the same jobs, they're getting the same pay and the same rank, but when they can't lift the 100-pound can of paint, her fellow workers lift it for her. And you can see with this what this does to morale problems when the men are working harder to do the physical work that the women cannot do, and yet they see the women are getting the same pay. And that is one of the big problems in enlisted persons' jobs in the military today.
And Mrs. Schlafly, another one for you here. You say that women already have certain rights delegated by laws which have already been enacted, but are these laws enforced? Don't we need ERA as part of the, quote, supreme law of the land, close quotes, to ensure proper enforcement of such laws?
No, we don't, and nobody has been able to show any way that the Equal Rights Amendment will extend the effect of the Equal Employment Opportunity Act of 1972. That law is completely extensive. It requires equal pay for equal work in hiring, in pay, and promotions. The enforcement is very aggressive. It is under this law that the women have won big multi-million-dollar settlements against the biggest companies in our land. When they won a $38 million settlement against the phone company had to give back pay not only to women who hadn't been paid what they should have been paid, but also to women who hadn't been promoted as they should have been promoted, and even to women who had not applied for jobs because they didn't think they would get them. Now, that is the type of government enforcement on our companies today. As a result of what was forced on the phone company, they are under their affirmative action requirement to get the women in all the categories. And that means that they have had to recruit men to come in and get the jobs answering the telephone, and they're under a federal court order to try to find women to climb up those telephone poles carrying 40 pounds of gear in equal numbers. Now, I think it is just simply unreasonable to take the position that there's no more reason why more women should be answering the telephone and more men climbing up phone poles with 40 pounds of gear. But under the aggressive enforcement of the existing laws, they've got to produce their quota in every category. Well, ERA doesn't add anything to that, and it's more than I can see what women would want to add to what they've already got in the strong arm power of the federal government.
Brian, would you like to? Yes. Mrs. Schlafly stated that women already have certain rights delegated by laws which have already been enacted. And the question is, are these laws enforced? Don't we need ERA as part of the, quote, supreme law of the land, close quotes, to ensure proper enforcement of such laws?
Yes. These laws that have been referred to refer to equal pay, and they have not been equally enforced throughout the land. You have just to look around you to see what you can see with your own eyes. How many waitresses, as I said earlier, can afford to take a case-by-case discrimination situation clear up through the courts? Sure, maybe Bell Telephone was able to do it, some women there, but very few women in this country really work for the great big companies. And as far as to lifting weights and that sort of thing, there are women that shouldn't be lifting heavy weights. There are men that shouldn't be lifting heavy weights. You'd be hired for the job by your ability, your physical ability to fulfill it. Now, we need ERA as part of the Constitution because those laws that she just referred to have just to do with pay. They have nothing at all to do with inheritance laws, with pensions, with insurance, with any of this other discrimination. And laws that are not written into the Constitution, they can be changed just as easily as they were passed. So it's not a concrete commitment to the future. There have been some very sweeping statements made about the Equal Rights Amendment tonight, and I would just like to mention, if it's so wrong, then I wonder who supports the Equal Rights Amendment. Well, the last 6 presidents of the United States supported it, 35 state legislatures, which make up 4/5 of the people, and over 200 organizations, including the American Baptist Women, American Bar Association, 26 affiliated unions of the AFL-CIO, the American Home Economics Association, the American Jewish Congress, American Veterans Committee, B'nai B'rith, the League of Women Voters, Homemakers of America, the National Coalition of Catholic Nuns, the WCTU, and the General Federation of Women's Clubs, to name just a few, and I don't think they're sexist.
This will be our last question. We just skimmed the surface, but this is directed to Mrs. Bayh. Is it not true that women have had an economic disadvantage for over 200 years? Therefore, is it not simple justice to support a boycott for our equal rights?
I wonder if they're referring to the boycott of conventions in the states that have not passed the equal rights.
The Equal Rights Amendment is very simple in its language. It just says equality of rights can't be denied or abridged on account of sex. But by its very simplicity, that means there are no exceptions. When the Equal Rights Amendment was going through Congress, a number of the senators and congressmen tried to put exceptions in it to save us from the horribles we've been discussing. When it came out of the House committee, it had the Wiggins Amendment attached to it, which would have exempted women from the draft and from combat duty and saved some of the other laws that help women. That was knocked out on the floor when the ERA proponents demanded that there be no exceptions. And then it went over to the U.S. Senate, and Senator Sam Ervin proposed 9 separate amendments to the Equal Rights Amendment. One of them said, except that it won't require women to be drafted into the armed services. The Equal Rights Amendment, people absolutely defeated it overwhelmingly. They demanded that it be defeated. Senator Ervin proposed another amendment that said, except we won't put our young women in military combat duty. The ERAers defeated that. They demanded that women be equally subject to combat duty. The next amendment that he proposed said, except that we won't take away the special protections of wives, mothers, and widows. That amendment also was defeated by the ERA proponents. Then he proposed an amendment that said, except that we won't take away the special protections of working women. That, too, was overwhelmingly defeated. He proposed another amendment that said, except we won't interfere with the laws about homosexuals. That, too, was defeated. Finally, he proposed an amendment that said, except we won't let it interfere with the laws that guarantee privacy to men or women, boys or girls. And that also was overwhelmingly defeated. The legislative history is tremendously clear that there are no exceptions in ERA. The proponents want an absolute, rigid, inflexible mandate that will prohibit your right to make any reasonable differences between men and women, anytime, any place, no matter how reasonable, no matter how much desired by the majority of people, no matter what good reasons you can propose. This is the rigid, inflexible mandate of the Equal Rights Amendment. And then beyond that, it gives to the federal government the power of enforcement. It gives to the federal government the power to decide just what kind of equality that should be. Maybe we can argue about what equality should mean in a given area, but it'll be the federal government that will decide. Maybe the Congress, maybe the bureaucrats, but certainly, finally, the federal courts. Now, there's certain areas where we all agree what it will mean. We apparently all agree that it will make women subject to the draft and subject to military combat duty. I don't know anybody who disputes that. There may be some dispute about what type of equality of financial obligation will be imposed upon the wife. We know it will have to be equality. But how that equality will be interpreted can be a matter of discussion as to whether that means 50% financial support or whether that means she's going to have to beg and plead for her husband to support her in the home, or whether if it means only equality in case the other one is incapacitated and about to go on welfare. It could mean a number of different things, but in any event, you won't be the ones to decide. It will be ultimately the federal government and ultimately the U.S. Supreme Court that will decide when. Only after ERA is ratified and after it goes into effect and after cases are brought. And then it's too late if you don't happen to like the decision that the Supreme Court is making. I believe my views were distorted when I was accused of wanting to leave all power at the state level. I clearly said that under our system we have a very wonderful interlacing system of checks and balances between the federal and the state governments and between the legislative, executive, and judicial branches of our government. We have some powers at the state level, like marriage and divorce, some powers at the national level, like providing for our military defense. That's all well and good. What I don't want to do is to give more power to the federal government. I think they're not doing a great job of solving all the problems they've already got, and I don't see any evidence that we'd be better off if we gave them another class of power. I noticed that my opponent did complain that some school rejected her as a woman. I think schools have got the right to make that decision to take only girls or all boys. Most people like co-ed schools, but I don't want to wipe out the right of that minority of our people who like to go to single-sex schools. I think they should have that right. Now, we were told that the polls say that the American people support the Equal Rights Amendment. The best poll is in the ballot box. And when ERA has been put on the ballot, as it has been in New York, New Jersey, Wisconsin, it has been overwhelmingly defeated. Even in the state of New York, where the state ERA was put on the ballot, and where they had all the media on their side and all the politicians on their side, and the ERA propaganda illegally being put out by state offices at the taxpayers' expense, the voters came out and overwhelmingly rejected it by a margin of more than 400,000 votes. ERA was even rejected in the state of Congresswoman Millicent Fenwick. Apparently they didn't buy her arguments there. When you put it up to the voters, they don't want it, because they recognize in it something that will do absolutely nothing for women. We were asked who supports and who doesn't support the Equal Rights Amendment. I think that the big organizations are opposed to the Equal Rights Amendment. In addition to the 15 states that have consistently voted no, and the 3 states that have rescinded their previous ratifications, and the 3 states that voted decisively no on referendum, we have many large organizations such as the Veterans of Foreign Wars, the American Legion in many states, the Farm Bureau in many states, the General Federation of Women's Clubs in many states, despite what their national board said. In the states of Virginia, Illinois, and most of the other big states, their state organizations have come out against the Equal Rights Amendment. We were told that the Catholic nuns are for the ERA. Well, I guess they're among the group who think ERA will help them to have the ordination of women. But the big Catholic organizations, as the big religious organizations, are all opposed to the Equal Rights Amendment, including the National Council of Catholic Women, the Catholic Daughters of America, the Knights of Columbus, the General Association of Baptist Churches, the Southern Baptist Convention, many Churches of Christ, many Jewish organizations, and on and on and on. The really big organizations are opposed to the Equal Rights Amendment. I think we've got in the Equal Rights Amendment an idea whose time has come and gone. It was born of the era of women's suffrage, and for 50 years all those congressmen had the good judgment to leave it decently buried in committee. It was abandoned and disassociated by most of the respectable people in this country, and along about the late 1960s, the women's liberation movement came along and saw in it the vehicle for the achievement of their objectives. And it was a few dozen women who went down to Congress and demanded that it be voted out. Most of the states that ratified it did so without any debate or hearing. They just called it up, and it was just as though somebody stood up and said, let's give 3 cheers for the ladies, and they all voted aye. But in the states that have held hearings, that have studied it, that have had task force reports or had hearings every year, it has been decisively and repeatedly rejected. In our state, it has been voted on by at least one house of our legislature every year for 6 straight years, and every time it comes up, it loses by a bigger margin than it did the preceding time. And yet the proponents come along and they want to extend and prolong this agony for 7 more years. They're just like a losing football team in the last quarter that demands that another quarter be played to give them time to catch up. And they hope by their bullying tactics of calling a boycott on Virginia apple growers and a boycott on Florida citrus growers and a boycott on convention cities that they can browbeat people into accepting something that they do not want and do not accept any merits for. I think it's very sad that we were told that ERA will give women options and choices and freedom. American women have the great freedom of living in the greatest country in the world. We have the great choice, the great option to choose your life any way you want. You can go into the workforce on the basis of equal pay for equal work guaranteed by federal laws. You can be a homemaker with the rights of the wife protected by state laws. You can do both at the same time. You can do both at different times. There's nothing holding women back except the cages they have built in their own minds. The American woman is the most fortunate class of people who ever lived on the face of the earth. And the whole idea that she's a second-class citizen is simply a myth that has been built in the minds of people who want to resurrect something that came out of the days when women didn't have the right to vote. All those things have long since been taken care of. And I would hope that the Equal Rights Amendment will die on March 22nd, 1979.
Now for her summation, Mrs. Bayh.
I have truly enjoyed tonight, and I thank you for all of your attention and your interest. Several comments were made by my opponent in her closing remarks. I want to point out that women have always been there when we've had our unfortunate wars. Nurses have been in the fields to help take care of the needy and those who needed them. Women have always been there when they were needed. When ERA would not deny single-sex schools that were private. A Library of Congress legal opinion states that. Now, as to ERAs being defeated in various states across the land in polls where votes were taken, if I believed some of the lies that my opponent and her followers have been spreading in those states, I would seriously consider voting against ERA myself. But I have dug deeply and I know the truth. For example, in our own state of Indiana, my opponent was on television, photographed, tearing up her Social Security card, telling the women of Indiana that they would lose their Social Security if the Equal Rights Amendment passed. That would scare me to death if I saw that and didn't know differently. If it's a time that's come and passed, then it's a sad, sad, sad day for America. But it has not come and passed, and it will not go away. And if the remaining 3 states do not ratify before next year, and if there is not an extension, we will start right out the next day. We will not stop until true democracy comes to our land. Why do we need the Equal Rights Amendment? Well, while we are a society which places value on the home and the family, we have never recognized the true economic worth of that woman who's the homemaker. Economist John Kenneth Galbraith estimates that the services homemakers amounts to 1/4 of the gross national product of this country, and yet it's not even counted. What have we given the homemaker for her years of service? Have we granted this fortunate American woman economic protection? Let's take just a few examples. What about the wife whose husband works for the federal government? Is she protected by her husband's civil service pension should he die? She does not usually know that she receives a percentage of her husband's pension only if he elects to take a reduced amount for himself upon retirement. And what if he walks out on her after 25, 35, or 40 years of marriage or more? She receives not one dime if he has worked for the federal government. Under the current law, when such long-term marriages end, the ex-spouse loses all rights to pension benefits and medical insurance. What happens to the 40-year-old wife whose husband dies unexpectedly after 20 years of marriage? In 42 states, a woman would have no right of ownership to any assets acquired through her husband's earnings during that marriage. In some states, this means a woman may not be entitled to any share of the estate. In only 8 states, women are assured of inheriting 1/2 of the property acquired during their marriage. The myth also remains that most widows are protected through either Social Security or their husband's pension plan. Unfortunately, a woman must be 60 years of age before she can begin to collect her husband's Social Security. And what about pensions? Only 2% of all older widows receive benefits from private pension plans. The retirement situation for working women is not much better. Only 8% of working women belong to pension plans. And while the Equal Rights Amendment is vitally important to the homemaker, it is also necessary for the woman who chooses or must choose to work outside the home. Statistics show us that more and more married women are choosing to enter the labor force. 45% of all married women now work in the labor force. It is hard for many of us to believe that the traditional stereotype of that American family with the husband breadwinning and woman staying at home and 2 children is only 7% of our population. Many critics of the ERA say that there is no need for a constitutional amendment to protect the rights of working women. To those critics, I can only point to the earnings gap for women in 1965. In that year, women earned 63% of a similarly employed full-time male worker. In 1974, 12 years after the enactment of the Equal Pay Act and Title VII of the Civil Rights Act, this gap has widened to the point that women earned only 57% of a similarly employed full-time male. Much of what is being said in opposition to ratification of the Equal Rights Amendment is just plain not true. The ERA affects only government action. It does not interfere with interpersonal relationships between husband and wife or between parents and their children. It requires that the legal rights, opportunities, and obligations of both men and women be based on individual characteristics, circumstances, and need, rather than on the simple basis of the sex one happened to be born. Sex-based laws are unjust and irrational because they use gender rather than ability or need to determine an individual's rights, responsibilities, and benefits in this land of ours. The principle of equality does not mean that men and women must be treated identically. Equality does not mean sameness. Equal rights under the law means that women will be judged as individual human beings, not stereotypes. Equal rights means finding self-value and worth. It means self-respect and the respect of others. It means the freedom to choose without risking financial disaster to be a full-time homemaker or to work outside of the home, and the flexibility to move back and forth as need dictates. It means the economic security of being compensated fairly for our labors and the recognition of the non-monetary contributions that so many women make in the home. It means greater equality in marriage. It means credit. It means pension rights and property so that we have the resources when widowhood or divorce strikes. Our founding fathers and our founding mothers, many of them from right here in Virginia, sacrificed and won the war for independence because of their belief in the dignity and worth of the individual. It's now a little over 200 years later, and it's time that we finish that revolution which they began so many years ago and provide full equality for all individuals, male and female, your daughters as well as your sons, your granddaughters as well as your grandsons. Now is the time, right now, to stand up and be counted and to pass the Equal Rights Amendment and make it the voice and law of this great land of ours for all women in this country.
Well, when we have a debate, people ask themselves who won. We're going to have the judges up here give us a decision. Well, we don't propose to have a specific judgment in this kind of a case. But no, listening to this, and we were talking a little earlier, two debaters from the Middle West, and going back into that historical origin of political debates out in Illinois, the famous Lincoln-Douglas debates. And people ask who won those debates. Senator Douglas won the election and became senator, and Abraham Lincoln became president. I've even heard someone suggest, it could be that someday Mrs. Schlafly will become senator and Senator Bayh might even become president. But in any case, we think we are, the winners really are all of us. We're the winners because we've had the opportunity of sharing with them in these presentations. We've had outstanding spokespersons. Advocates of their points of view, giving us the benefit of their own study and their own thinking, and letting each one is up to us to make up our own minds and what influence this may have to bear. But we do want to thank them on behalf of everybody concerned. We want to give our thanks also to the Virginia Foundation for the Humanities and Public Policy. We'd like to see the discussion of current concerning public policy in the framework, in the context, perspective of the humanities. That's what we're trying to accomplish in this kind of thing. Give our thanks to the women of the National Secretaries Association, Miss Daniel and her committee, which did so much in making the preparations. Appreciate the members of the faculty and those participating in the panel and helping us getting things organized, participating in the discussion. And above all, thanks of us all to our two distinguished guests. Thank you very much.